Two Constitutional Court justices in a case involving former President Jacob Zuma in 2008. Testimonies have been taking place throughout Monday and Tuesday, and today let's take you back there live.
And how to deal with it. Ultimately, she sought advice from Judge Mokgoro on how to deal with the matter. She had thought that she might use the forum where she was a committee member. This forum entailed sexism, racism issues among the judges. And this explains why it took Judge Nkabinde a bit of time before the matter could be escalated. When the matter was ultimately in the hands of the Chief Justice and his deputy, she had felt that they are the ones to make a decision on how to handle this matter or this issue as the leaders of the court. She therefore felt that she could not be referred to as the complainant. In this instance is the same way as Judge Jafta. They both feel they should not be referred as complainant because it is the institution itself whose integrity is in question, and also the influence which might be for that institution, not necessarily the two judges. It is submitted that her evidence was credible and that it should be accepted as truthful. It is also strange why Judge President Hlophe, when Mr. Zuma's matter was at the Constitutional Court, had raised it with the two judges on different occasions. He had known that the Constitutional Court was seized with the matter, but still wanted to discuss it with the judges in that court. To show that he had a peculiar agenda, that is Judge President Hlophe, instead of congratulating Judge Nkabinde personally at the function where they met or they had both attended, or congratulate her telephonically, he instead wanted to congratulate her in her chambers. It is submitted further that this did not make sense. Coincidentally, Judge Jafta had felt that he needed to caution Judge Nkabinde about Judge President's motives for the meeting. In State versus Mayekiso, the case that I mentioned on Tuesday, Judge President Hlophe showed that he strongly disapproved of an assessor discussing the case with another person not involved in it. He took a decision that the proceedings should be declared a nullity and that the case be started de novo. Clearly, he had felt that the conduct of the assessor had contaminated the proceedings. So this is the same way in our situation, insofar as Judge Hlophe is concerned, with the approaches or the attempted influence to the two judges or justices. It is submitted further that it is submitted that the evidence that he had no intention to interfere in the work of the two judges must be rejected as false. It is submitted further that there is no identifiable motive why the two judges would decide to fabricate their evidence against Judge Hlophe. It is therefore submitted that the evidence presented to the tribunal shows that when Judge Hlophe visited the two judges, he had the intention to influence them. It is submitted that it was very inappropriate to initiate conversations about Mr. Zuma's cases, well knowing that the Constitutional Court was seized with the matter. He wanted to create the impression that the conversation he had initiated about Mr. Zuma's cases was innocent. It is noteworthy that during the conversation with the two judges, Judge Hlophe had said that there was no case against Mr. Zuma and that he was being persecuted. It is submitted that his statement to the two judges that there was no case against Mr. Zuma was clearly an attempt to influence them in the matter. Courts are expected to function independently, without interference, and impartially in the execution of their duties. All courts are constitutionally protected from the interference and are supposed to be independent in terms of Section 165, subsection 2 of the Constitution of the Republic of South Africa. I now refer to the two cases which confirm the above, that is the Van Rooyen and others versus the state and others. It is a 2002 matter, volume 2, SACR. It's a constitutional court case. The second one is Dilange versus Smuts and others. It's a 1998 volume 3 SACR. Is also a constitutional court matter. Furthermore, Article 5 of the Code of Conduct of Judicial Conduct provides that a judge must always act honorably and in a manner befitting judicial office, even outside that court. I'm now getting towards the end. It is therefore submitted that for Hlophe JP to start telling Judge Nkabinde and Judge Jafta that there was no case against Mr. Zuma, knowing that the court was seized with that matter, was completely improper and gross in the conduct, or his conduct was improper and having committed some gross misconduct at the same time. In conclusion, it is submitted therefore that looking at the evidence as a whole, it was clear that when Hlophe JP says Tembeleki Nina, he was trying to influence the two justices. Perhaps something that I feel I just need to reiterate here is the issue that I raised with Judge Hlophe during the cross-examination, that he chooses to speculate when it suits him. I'll give an example why I made such a submission. He said, or he testified that because of the absence of the minutes of the meeting that was held by the justices in the Constitutional Court, the expert was therefore unable to understand or to provide the second meaning of the phrase "Sesitembeleki Nina." The issue which was also mentioned by that expert when he came to testify. But when I posed the question, why was it like coincidence that the two judges immediately warned each other, or Judge Jafta specifically warned Judge Nkabinde that the possibility of him discussing, that is Judge Hlophe, possibility of him coming to discuss the Zuma matter is there, and be careful, even if I'm not using the correct words, but words to that effect. Why is he now, what could be the reason why they would warn each other and it ended up happening? Then he is not able to speculate as to why, but at the same time is able to speculate the possibility of not having the second meaning of Sesitembeleki Nina by the witness that he called. Thank you very much.
I apologize, Justice Labuschagne. If we are to follow, as I assume we will, would it be of any assistance if we circulate our heads now? We've had certain logistical problems that my learned friend had to have them copied commercially this morning, but we do now have enough for everyone.
Yes.
I was just wondering whether we should circulate them to the members of the tribunal as well at this stage.
Yes, it will be convenient
Thank you.
to have them as soon as possible.
Thank you, Justice.
Thank you. We adjourn for 15 minutes.